Colin. How's it going? You look troubled. What's up?
I'm supposed to produce a video about public records that contain confidential information, but I don't know where to start.
How about by asking, is confidentiality a reason not to make records available?
Well, it can be, can't it? I mean, GS 132.12 lists various criteria that constitute confidential information, and many of those are going to be found in archival materials.
True. Especially personally identifiable information such as names combined with electronic signatures, social security numbers, or driver's license numbers.
Then there's also federal statutes that declare records confidential, such as the Health Insurance, Portability and Accountability Act, HIPAA, or the Family Educational Rights and Privacy Act, FERPA, covering medical and student records at the federal level.
But then there are things you'd think were confidential but aren't. These include employee histories, salary information, and promotion information.
Which is why newspapers can publish them.
Exactly. You're also going to have to cover instances where confidential and non-confidential information will occur within a document. For example, someone's social security number is mentioned in a document otherwise containing non-confidential information.
I know, and to explain how such commingling is not a reason to refuse access to a document, and also that the agency is required to separate confidential and non-confidential information and bear the cost of that separation. And that separation is normally achieved through removing or redacting the confidential information from the record before public inspection. But none of that makes for an exciting video though, does it?
Well, you could provide a talking Sharpie describing its life in redacting.
You're not taking this seriously, are you?
Okay, Colin, you want serious. There needs to be something about public information rather than public records. You know how just because a record is public, it doesn't necessarily follow that all of the information it contains is public.
Or that marking a document private doesn't make it so.
Make it so, being your chance to show a picture of Jean-Luc Picard.
Make it so.
What? No. Getting back on track, I need to explain how confidential information may still be available to certain people under certain circumstances. For example, a grievance proceeding may mean parts of a personnel file come under review, or you may want to let a contractor see a blueprint for a building.
You haven't mentioned electronic records and how protecting confidentiality in them can even be more complicated.
I know. And I need something about how a deleted file will still be on a hard drive and can often be recovered through computer forensics, and how every step should therefore be taken to delete information, for example by emptying the recycle bin. And that when disposing of computers, it's essential to ensure that all information is removed and or hard drives rendered inoperable.
Ooh, this might be your chance for some Hollywood-style explosions of hard drives.
I know that's how they're sometimes rendered inoperable, but no.
I suppose instead there'll be some boring image while you explain that to protect confidential information, consider storage in a separate, password-protected location or on just one computer.
Boring, but important. As is the fact that information stored electronically is still information that's open to public inspection. And it's important to ensure that all confidential information is redacted before information is shared. And this could often be complicated. For example, marriage licenses have dates of birth, mothers' maiden names, and other information often used to verify a person's identity. And although this has often been available through courthouses, increases in identity theft mean people do not often want this information available online. And I'm also going to say that folks should consult their legal staff for advice on what should or shouldn't be available online.
Legal staff? Like Judge Judy?
No, not like Judge Judy.
You really have no sense of humor. I bet instead you'll go on and on about emails.
Again, they're important. Did you know that the general advice is not to use email for confidential correspondence? And that email between offices in the same building may involve the email travelling outside the building, town, or even the country, making it potentially open to view. If you must use email for confidential information, work with your IT staff to make it as secure as possible.
Then there's human error. It's all too easy to send something to the wrong person or inadvertently include confidential information such as the office credit card number, often without realizing an error has occurred.
Or the reply all error. Remember that time you...
No need to mention that.
I'm thinking of finishing with reminding people that North Carolina is one of the most open sunshine law states. And that while there's grounds to refuse access to a record because it's confidential, you better be prepared to cite the federal or state law that makes it so. And don't mention John Luke Picard again, he's not in this video.
Well, he should be. I mean, really? That's your big dramatic finish? Can't you come up with anything better than that to end on?
There's always this. If you need further help or information, contact the Government Records Centre at the State Archives at 919-814-6900 or email records@ncdcr.gov.
Patrick Stewart would have done this better.
You can also consult our website, archives.ncdcr.gov, and blog ncrecords.wordpress.com.